The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. Welcome to my webinar on ADHD school strategies. I'm so glad you guys are here. I'm hoping that you can hear me well. If there's anyone who can't, just let me know through the question box or the chat box, one or the other. So I want to introduce myself and just tell you a little bit about myself before I continue. Again, my name is Karen Lowry. I have 4 children, and my youngest is 19, who is really the one that got me involved as much as I am involved with ADHD. So I have a personal history of a child with combined type ADHD as well as learning disabilities. So that's how I got involved with learning a lot more about ADHD. I reached out to CHAD. Many times people haven't heard of that before, CHAD. CHADD. It's a nonprofit organization that does provide a great deal of information and support. And that's kind of how I started to learn about it. I then became a family certified parent-to-parent teacher. So I've done many webinars through CHAD trying to give information and support, because as we all know, and for all of you who are here, you are here because you're trying to provide support and advocacy for your child. And you know that the most important way to do that is to have the right information. So that's, how I felt then as I was learning, and I was trying to reach out to others as well, so they would have that information as well. I then decided to become a certified ADHD coach, and my genre is pretty much families, children, teenagers, college students who struggle with the impairments of ADHD. And as I began that journey, I realized that so many times when I have a client who I'm to coach, they do not have the appropriate school support. And you can't coach someone if they don't have that support, because if they don't have it, then it creates much stress in the family, as you probably have experienced, where a child is not coming home with the right homework, right books, not handing in homework, having missed assignments. You're getting calls from the teacher. You are put in that position of responsibility to make sure that child does what he's supposed to do. So I come into the picture, and then in that picture, the child is the client, and the child has to come up with goals, because that's what coaching is about, positive goals. But that child can't have those positive goals without adequate school support if it is needed. And so that's what this is really all about. And I think it kind of gives you that in a nutshell of why I am so about school support, because starting out as a coach and realizing that if that piece is missing, you can't adequately coach a client, and a client can't adequately come up with goals and a plan of action if that client is struggling in school and the support isn't there. So that's kind of how I'm involved with this advocacy piece. In addition, in case you haven't seen it, there is a handout, a PDF handout that reflects my slides. Please feel free to download that, as well as be aware that on there it talks about my website and how you can sign up for a free coaching session. So what I will also do is get through this webinar and then allow some questions at the end. So my goal is to hopefully, be done within 50 minutes or so it gives some time for questions. Any questions that I don't get to because of time constraints, you certainly are able to reach out to me through my website, send me an email. I'll be happy to always support any questions that you have. And again, please let me know if there's anyone who's not hearing me. I'm assuming that you're all hearing me. ADHD is a very complicated mental disorder. It is one of the most researched psychiatric disorders, and it is considered to be that in that category, even though I know it sounds like a negative category, and it is not meant to be, but that for lack of better words, that's what we call it. It is one of the most researched among all mental disorders in children, despite the fact that so many people don't believe in it. Or I think more than not believing in it are people who don't really understand the depths of impairment that it creates in the school. It's complicated, and for many, it is hard to accept and understand. And I think a lot of that is because um, ADHD is so behaviorally based that our assumption in this world is that if you have a behavior, then you should be able to control it. And if you can't control it, then your parent should help you control it. And that is what should be happening. So it's unfortunately you can't see ADHD, and it is just looked at something that is not necessarily, um, you know, uncontrol. It's something that they should be able to control. Yeah, of course, our kids can control. Our kids are smart and gifted, but they also need exterior strategies for that to happen, and that's the tough part for people to understand that. So here you see a picture of frustration. The many faces of ADHD, again, here are some behavioral issues that show a lot of impulsivity and hyperactivity. Some of that, it's hard to even say what are the triggers for each of those kids could be totally different. One could be totally bored. One could be totally confused, and they don't even know how to verbalize what their questions are. So one could have just really low self-esteem for ongoing issues. So remember that when you see these behaviors, behind all of those behaviors are certain triggers that need to be addressed by the school when it continues and interferes with the academics. And that's very important. Another face, and again, more boys than girls have the combined hyperactive impulsive type. More girls have the inattentive type. And so they are many times not even diagnosed very early because they're quiet and they are just not appearing to have any issues at all. And again, more faces, impulsivity, confusion. You can see here there's a guy asleep, fatigue, and that may be related to medication or ADHD that creates sleep issues, which it can. So again, the many faces that show, and here's a face that to me shows no lack of support in the school. And like I said in the beginning, I find so many that don't have school support, and they are frustrated. The parents are frustrated, and they demand out of their kids. They cajole, they punish, they bribe, and as that happens, the self-esteem plummets, and that increases the damaged parent-child relationship. So that's what you want to avoid. So where do you start? What is we're taking an imaginary child. What is impacting this child's academic success? We're going to first start with what is called a 504, and some of the details regarding the 504. It is part of the Civil Rights Law, part of the Rehab Act of 1973. It prevents discrimination, and it is considered to prevent discrimination in any area, mental or physical. It is important. It is the law that every child is allowed to have, it should have a free and appropriate public education. and that every child should be able to access general education successfully, whether they have a disability or not. So that's what a 504 addresses. A child with a disability, and we'll go into that detail of what those disabilities are. But a child must be diagnosed with a disability, and a child with that disability is having difficulty accessing education. Compliance is not optional. It is a federal law. And I so many times see on my Facebook page, my support page, and through client issues, I hear so much where it is assumed that when a child has a 504, it is information that is optional. So teachers believe that it may or may not be important to fulfill a certain accommodation on a given day. Totally not true. It is not a support base that has as many procedural safeguards as an IEP that we'll talk about later, definitely. But it still shouldn't be diminished as something that is optional and not really a law, because that is absolutely not true. Teachers are required to follow the 504 that is in place. Again, another biggie is many times people make comments that, no, your child's not subject to a 504 because he's not failing. That is not a legal requirement. You do not have to be failing to receive a 504 or an IEP. The difference here too is that the 504 to be put in place does not have to be in writing, although generally they are in writing. I've not really seen any that aren't in writing, but believe it or not, they don't have to be in writing. And they don't require parental input. They don't require parental permission to have a 504 in place. But I mean, what I generally see, of course, are parents who are going after and want a 504. But that's just the other part of the law too, in case that wasn't the case. So it is the degree of impairment, not the diagnosis. Certainly, anybody with an ADHD diagnosis does not necessarily need a 504 or an IEP or is eligible for it. So it is not just the diagnosis, it is how it's affecting that child. So for purposes of a 504, a disabled person is one who has a physical or mental impairment which substantially limits one or more major life activities. Now that's the tough part when you start interjecting a subjective statement like substantially limits, because that is of course up to the school and the parents to make that kind of a decision, and of course there may be some disagreements in that area. That's why I really talk about later on about the importance of documenting and proving how this kind of a disability sees itself, raises its ugly head, creates problems, and therefore is a substantially limiting kind of diagnosis in that particular child's case. Very important to prove that. Now, when I talk about major life activities, these are it. These are major life activities. And in the ones in red have been added, and the ones in blue, of course, are very ADHD specific. So in this case, what we're talking about in the school is learning. So here is a definition of substantially limiting, and again, it's up for assessing, what that really is. Does that impairment result in failure or underachievement when compared to same age non-disabled peers? Does it impact a major activity? Those what I just talked about, in particular, learning for our purposes. Does the impairment last at least 6 months? So in other words, does that impairment, if it's off and on versus pretty continual, it kind of reflects that diagnosis. If you were diagnosing a child with ADHD, again, you would be talking about a child with X number of behaviors that lasted at least 6 months, because the point of that is that they are continual. It is not like a 6-year-old that's a normal boy that's always running around. It is a boy that maybe has those behaviors that are very consistently affecting two environments, school and home, in a negative kind of way. So that's why they talk about impairment lasting at least 6 months. So here's the question I get all the time. How you obtain a 504. And again, everything that you do should be in writing. Request the support in writing to the person in charge. And again, different districts have different people who are at the head of the 504. I have seen guidance counselors be in charge of 504s. I've seen vice principals be in charge of 504s. So it just depends. That's the person who you need to be writing to. Then in your court, you're the one that sees all of the impairments and struggles. And those are the things you document, the issues that you're seeing. That, of course, in our case, we're talking about ADHD. Homework, missed homework, doing homework, not handing homework in, time management, not chunking assignments, organization, things like that that you see in your child that need to be addressed. Homework is another issue too that creates so much trouble. So many times I've heard children come home and, they spend the rest of the night doing homework, and the parent is the Gestapo agent, so to speak, trying to make sure that child does his homework. And that is not something that should be happening. Generally, the policy states 10 minutes a grade level. So if you have a fourth grader, it should be under an hour of homework. And that's very important to be looking at. You as the parent, seeing those struggles at home, that's really something that should be documented. And because that's going to allow accommodations in the 504. And yes, when I talk about having things in writing, yes, emails are fine to have in writing. And generally that's what we do, and just keep those emails. And in addition to all this documentation is anything teachers have said to you, because their information is valuable as well. And many times the teacher is the one coming to you with concerns. So with those concerns, as well as home concerns, all of those things should be put in writing. These are just some other things that happen that, again, people aren't aware of, that under the umbrella of executive functioning, that is run by that prefrontal cortex that is understimulated in our kids with ADHD. And these are the kinds of things that happen or don't happen for those kids. And getting started, remembering chores, just remembering and organizing, sequencing. And a lot of these things come into play even more so as your child gets older and is in middle school and high school, when you have to have a project and you have to be able to sequence, you have to be able to chunk and organize. That's when many times things really fall apart. And then reading comprehension, expression, those kinds of things may or may not be a learning disability. And remember that up to 50% of our kids do have some form of a learning disability. So it's always good to rule that out. If you see scores that are showing some deficit, it can be just related to an ADHD situation. They can have these kinds of issues along with a learning disability. Controlling emotions, part of that, analyzing, problem solving, and planning for the future. All of these things come into play as they get older. And I'm sure depending on the age of your child, you've seen pretty horrendous backpacks. That's why I like this picture. And that's another one. So once you put this in writing, what will the school do? The school must acknowledge, and again, the time frame is kind of iffy there. I've not seen a specific time frame that the law talks about. It has to just be within reason. They acknowledge your request. Pertinent information is gathered, like grades and teacher comments, standardized testing, behaviors. There's no specific testing that occurs for 504. just what's happening up to this point and looking at scores, behaviors, and so on that's creating some of these issues. Just like I said, no parental participation or signature for any kind of testing is needed. So then there's a meeting to discuss a formulated 504 that would allow for those accommodations that are needed in the areas of struggles. This is a list of some typical accommodations, and I would just suggest and point out that sometimes these 504s as well as IEPs are not specific to your child's struggle, and that's concerning. Remember that they are not supposed to just throw in a bunch of accommodations or one or two. These accommodations must specifically connect to the struggles that your child has so that you can evaluate whether or not a 504 is working or not. But these are some of the very common ones and some very important ones that can be very helpful to many kids. Extended time, peer notes, teacher notes, a different place to test, repetition of directions, visual instruction, behavioral management, change in test delivery, by that I mean whether the test itself has changed, the way to ask the question, or whether it's a verbal test versus just in writing. Use of tape recorders, a live scribe, which is a technical pen that records the lecture. Tailoring homework so that your child is within the district, within district policy. Incorporation of teaching strategies from special ed teachers. I mean, that would be nice. That's a huge deal. Can't really say I've ever seen that in a 504, but it's nice. Related services. Many times you think of related services related to an IEP, but you can have that in a 504. I've read that you can, although I generally see that in an IEP. So there's some variation in that, I think, depending on the district. Personally, I think that if you needed a related service, that you should have an IEP. You can have an IEP just for related service. If a child has a speech and language interventions a couple times a week, then the beauty of the IEP is that you're going to have goals that need to be followed. If you don't have those goals, you don't know whether you're moving forward or not. So I think IEPs for those services are pretty important. So although I've read this, I've never seen it in a 504, quite honestly. I've seen them in an IEP or an IEP itself, separate. Like you could have a 504, but you could have an IEP speech. So now, once it's in place, very important is to follow the 504 and have set up some kind of communication between home and school. Establishing that communication is very crucial because otherwise you don't know whether it's working. So the big question is, how do I know that a 504 is really working? What to do if the 504 is not providing FAPE? Now, as a side note, again, I just want to reiterate what FAPE is: free and appropriate public education. So what I did, and I don't think it's in this, it was another PDF. But what I did is kind of made FAPE, each letter stand for something important so that you can remember how to establish FAPE. And it's very simple. And actually what I should do is I could write that down so that you could see it. Probably would make a lot of sense. So for the F, I just said find documents, which means, and that's just being very short here, finding documents that indicate whether or not your child is having success in a 504, whether it be grades, whether it be organizational things, whether it be teacher comments, anything in documents that would help you understand that. Under A for FAPE, advocate, which I think you're always advocating as you are ensuring that the 504 is working. And P is prepare. And that is an example of that is just knowing what is going on with your child, what is being followed, who understands that your child has a 504. And as a side note, any kind of meeting I think is important for recording, and that's part of prepare. And I think I talk about it later, but just as a side note too, for the recording part, just you can record. There's nothing against the law about that, but you must let the school district know ahead of time, because if you're recording, they will record as well. And for E, I just said educate about laws, and that's what you're always doing when you're trying to prepare and advocate, find documents in order to come up with what FAPE is, which is ensuring that your child is being educated just like every other neurotypical kid is being educated. As I said, I didn't say this. So anyway, the next thing is if you are moving forward, the 504 is not working, you request in writing to the child study team a psychoeducation evaluation. You already have the medical diagnosis of the ADHD, so this evaluation will determine whether there are learning disabilities, as well as areas of struggle that come from an ADHD diagnosis that will be seen in the evaluation. And again, these struggles, this is very important if you see struggles at all, to rule out any kind of learning disability, because of the fact that up to 50% of our kids do have some kind of a learning disability. Again, the child study team must respond within a reasonable amount of time. And that's usually 7 to 10 days. I think I skipped one here. To further explain the IEP, it is under the IDEA, the Individuals with Disability Education Act. The IDEA promotes FAPE, free and appropriate public education, and emphasizes special education and related services designed to fit their unique needs and prepare them for future education, employment, and independent living. The further education and the emphasis on transitional services are new in the IDEA 2004. Previous to the 2004 was the 1997 IDEA. So the fact that further education is now in there, as well as transitional services, which means services that must be addressed by the time the child is 16 as he moves forward through that school system, which is related to what he will be doing in the future. So I think that's a very important part that has been now added to the IDEA, because I think it just further reinforces the importance of school support, because now we're addressing further education. If our children don't have FAPE, they're certainly not prepared for further education. So I think that's a huge deal that we now have that in the IDEA. So why evaluate? And I really have touched on some of this anyway. Again, because of the great number of children with ADHD who have a learning difference, because benefits of testing allows evidence of issues that show learning difficulties. It is performed by a licensed psychologist and must be trained and have experience. The school pays for that evaluation and is required to just really look at the areas of the suspected disability. So going into an evaluation, there is a suspected issue, and so that is what is looked at. Areas in the process can include the observation of children, looking at medical records, school records, consulting teachers, and you, the parents. So all of that along with the actual evaluation in writing. In this case, consent is required. You should be told what tests are being done and who will do them. Within this letter of request, document objective reasons and requests that include current struggles at home and at school, grades, teacher comments. The most objective that you can be is the most important. You must have objective data so that you can show that this child certainly needs some evaluation and some kind of school support. Very important. There is some state variation. Usually for the first evaluation, the requirement is a 90-day completion. That means from the time that the parent signs for testing, approves of testing, to the day that you all sit down and determine IEP eligibility, 90 days. I've seen it 60 days as well. But sometimes states vary a little bit, and sometimes it'll be 90 for the very first evaluation and then 60 following that for a second evaluation if that happens. Very important is that you receive that test, those results, prior to the eligibility meeting so you can look at it and be prepared. Consider bringing someone with you, either an advocate or a spouse or somebody just to be with you. It gets very stressful. There's many people at the table, and I'm not saying that you're going into a meeting that's very adversarial, but it can be because you're going in emotional. This is a very emotional deal when you're talking about your child, and it's important to have that kind of support, I think, including recording. That's also very important because if you don't record, sometimes you can certainly forget some of the details, and so do the school staff as well. And I think it's very important that you have that all documented so you can go back and re-listen to all of it, and they can as well. So as I said, the time frame is different, 60 to 90 days. The testing, it kind of varies. Sometimes it can take 5 to 6 hours. Obviously, it won't be all done in one day. It could be a 2 to 3 day testing period. It could be a little less than that. If you decide to do a private evaluation, ask for recommendations from your pediatrician or your local and state psychological organizations or an ADHD coach. The parent owns this evaluation and can decide who they see. The tester should include recommendations to allow for success. That doesn't always happen, but in particular, they will pretty much, at least the ones that I've seen for schools, they'll defer to the child study team to make that decision, so they don't really come up with necessarily specific recommendations. So for eligibility, the child must meet the eligibility criteria in at least one of 13 categories. The disabling condition must adversely affect the child's educational performance, creating an educational need. And again, remember, this does not mean that the grades are plummeting or the grades are not plummeting and therefore it's not adversely affecting that child's performance. You can certainly have some kind of plummeting, but sometimes the plummeting is an off and on kind of a thing that sometimes is explained away by if he would only, it's explained away by his behavior, which is not acceptable. The child must be in need of special education and related services. That educational need is not necessarily reflected by grades. I can't emphasize that enough, and that's That's what I hear a great deal. Now, here are the 13 disability categories, and the first 3 in red are specific to ADHD. One side note that I'll mention, and this is like a personal, I guess this is a personal opinion. I haven't really read it anywhere. But there are 2 situations I've been involved with where the school wanted to, well, one child had a diagnosis of emotional disturbance from another state and maintained that diagnosis, and it was never switched to ADHD, which is what he has. And in another case, the school was adamant to switch, actually two other cases, was adamant to switch the ADHD diagnosis to emotional disturbance. And I haven't figured, I'm trying to figure that out. The only thing that I can come up with is that I think that emotional disturbance is very, very narrow a diagnosis and a very narrow classification to put on an IEP. ADHD includes emotional regulation issues from executive functioning deficits, along with a multitude of other impairments. If you are only looking at emotional disturbance, you are taking out the majority of the symptoms of ADHD. So it really, to me, personally, it's a red flag when a school is trying to switch a classification. And I've seen it happen, like I said, a couple of times, and there's never been an explanation for it. But I would caution you to be aware of that and know that, the diagnosis of ADHD is the diagnosis of ADHD. I mean, certainly there are kids with emotional disturbance that don't have ADHD, and that would be appropriate. Even though the IDEA is saying, yeah, you can use that. If your child has ADHD, you can use that. I don't think it's a great idea myself, but that's my 2 cents. Now you hear about the different evaluations, and I'm not going to say that I am like an expert on the major differences between the psychoeducational and the neuropsychological evaluations, but I can tell you that the neuropsychological evaluations are going to be more medical, and the psychoeducational are the ones that are done by the school that are more involved with academics. And that's kind of an overview, kind of a generality. It's certainly if you go outside the school and decide to do a private evaluation, you may decide to go neuropsychological to gather a little bit different and more information from the psychoeducational eval that you had in the school. And this information just shows what's under this neuropsychological evaluation, the Wechsler intelligence scale for cognitive abilities, memory scales, and that's kind of also, you might even do this type of an eval if you were trying to confirm an ADHD diagnosis, because some of that is involved with ADHD issues like attention and so forth. The psychoeducational, measuring emotional, behavioral functioning, cognitive abilities, academic levels, kind of things that you would expect, processing abilities. And a lot of times with our kids with ADHD who are tested in the school, I see more than not areas of working memory and processing that are not functioning well at all. So you see that a lot. So there are some variations in both tests, just so that you're aware of that. So getting back to the evaluation, a meeting will be set up with the child study team to discuss the results of the eval. And like I said before, make sure that you have that test and that you've looked at it. You're going to walk in and you're going to see a case manager, and you should see these people, a special ed teacher, a general ed teacher, a school psychologist. You might see a social worker. Generally, in the first meeting, you do. You might see speech and language. And they have already reviewed this testing, but they will go over it with you step by step. And the IEP may or may not be granted based on what they've decided the results of the testing is. Many times I have heard that there must be a deficit, and some districts will have a way of coming up with whether or not a deficit, like it's a formula, whether a deficit is there between academic achievement and a cognitive ability. The IDEA clearly states that that is no longer needed for IEP eligibility, but districts will continually talk about that there is not the deficit that is needed between these two things. In other words, there has to be that deficit between what they can do and what they do. The scores can appear average, and my warning is be aware of subscores. And what I see is you will see different groupings of subscores, and the end result of those subscores comes up as an average score. But if you look at those subscores, you will see low average in areas that are very consistent with ADHD, like I said, working memory and processing abilities. So although they're many times quick to say that all of these groupings are average, if you look and see where areas are low, and you can connect it to struggles that you see that relate to that information, that's important information, and that's information that's needed for the development of some kind of a support. It is not to be dismissed. There seems to be some difficulties with using the word dyslexia in schools, although it is definitely not considered to be a medical diagnosis. Repeating a grade does remediate, is the thought, but the research-based intervention, the research says there needs to be intervention that's been researched. Repeating a grade does not remediate. Even mild dyslexia needs support. You can see preschool, at preschool there could be some at-risk signs. And although I think there's been differing opinions about whether or not a diagnosis can be made early, what I have read is that it can be made by first grade. Schools will say they can't diagnose, but again, it is not a medical diagnosis. This is a learning issue. This is a learning issue, a language-based learning disability. It is an academic diagnosis. It is a word that is accepted by the IDEA. Many times schools won't use that word. They will use SLD, specific learning disability. I mean, it's not really that big of a deal, I guess, as long as your child gets the correct support. If it's argued that the disability cannot be called dyslexia and it should be called specific learning disability, I don't think that that's anything to fight about. What is more important is that you have researched interventions, reading programs that can remediate your child's issues. So let's say you have been given an IEP. One of the most important parts in the beginning is PLOP, present levels of performance and educational performance. Present levels of those present levels are very important because it does govern the goals. And those present levels come from all of the teachers. It comes from behaviors in the classroom. It comes from grades, difficulties in the classroom. All of those present levels of performance must be listed in the IEP. The IDEA 2004 again added another, the need for functional, which is non-academic. And that's, I think of that as more like ADHD, because we do look at that as functional issues many times, right? We're not talking necessarily about, unless you have a child too that also needs remediation for a learning disability, you have a child with the functional issues of organizational issues, time management, those kinds of things. Those again are just as important to address. The goals in the IEP have to be SMART, are SMART, which is specific, measurable, action words, relevant, and time limited. Those are what each of those letters stand for. So extremely important is that they are measurable, because obviously if you're going to come up with an IEP, you need to know that it is going to work, and you need to have a way of measuring it. One time I saw an IEP, it was like ridiculous. Based on that IEP, every kid in the world could have an IEP. The goals were totally curriculum based, that child would fulfill the need to address the history curriculum and be successful or something like that. That's something that we want all our kids to do. But I think that, again, that's reflective of the importance of the present levels of performance. That's where you look at what are the issues about my child that I need to address in the goals, not the curriculum. If he was just able to follow the curriculum, we wouldn't be talking about the IEP to begin with. So again, the IDEA came up with a statement of special ed and related services, supplementary aids and services based on peer-reviewed research. The IDEA also, although I do see this in a lot of IEPs, but they do specify to have annual goals without short-term objectives. But again, there's certain things that are not important to fight about. But these are different than they used to be. There used to be benchmarks and short-term objectives. They are not really supposed to be in the IEPs any longer. For some reason, they are sometimes. So again, you have measurable goals, and you need to make sure that you come up with you understand as the parent how they will be measured. How will they be measured? When will you receive reports that show they were measured? And where is your child in that goal at that time? Generally, these assessments are done quarterly, so they kind of match up with the report cards, but you do need them. Remember that with an IEP, it is mandatory to have an annual meeting. An annual meeting is just to set up the IEP for the following year, but anyone can call a meeting. If you have concerns as a parent, you can always call a meeting, and they'll have it. So I just wanted to separate these words. Modifications, which are what you see many times in an IEP, are changes in the curriculum that make different requirements necessary, whereas accommodations changes are how information is assessed. So in the accommodation piece in the 504, the expectations for learning that particular curriculum are the same as all the other neurotypical kids. It's just how that information is assessed. For instance, if you might have that homework accommodation where you don't do 20 math problems, you do 10, but you're doing the same math. Where modifications, the requirements could be different. There could be different ways of doing the math, or maybe just a totally different math for remediation purposes. So it's very, very different depending on the kind of support your child has. So when the child says no to an IEP, there are reasons for that. They may say there's no learning difference, so you don't need an IEP. And again, totally not understanding and accepting how impairing an ADHD can be. I personally think in some kids, ADHD is more impairing than their learning disability, without a doubt. So some districts will turn away without a learning difference because they don't believe that ADHD impacts assessing education, which we all know that it does. They also may say that your grades are not below a C, so you're fine. Or that, like I said before, the discrepancy formula is non-existent. So these are the procedural safeguards when there is disagreement with a school evaluation. You can request an independent educational evaluation if you disagree with the findings in the school evaluation. And the school must respond to you and allow you to have that based on the school must pay for that. And this is just a private evaluation. It can include all of those issues that we talked about before: academic, cognitive, assistive technology needs, speech, sensory needs, neurological functioning, any skill evaluation that relates to an educational need. The school must respond by agreeing, or they can also file for a due process hearing. And the reason is that they believe that their evaluation was okay and they want to prove that. If they say, okay, the evaluation is paid by the school district, that school doesn't have to choose that evaluator. You can choose that evaluator as long as that provider is qualified and is not employed by the school. So this is statute of limitations is new, that this filing must take place within 2 years of a school's action or inaction. Prior written notice is very important as well. It must be sent within 10 days. And prior written notice really is that the school can't just say no to something. In that regards, the support services or the change of support services, or if your child even has an IEP and they want to change placement. They can't just say, we're going to do this and move on. They have to provide prior written notice, which is to explain why. That's very important. The district is mandated under child fine to evaluate for a suspected disability. And we talked about the 60 to 90 day. The district is required to include parents as a team member. Remember that you are a team member. They must meet annually. I have heard this before too. I find that amazing, but a district cannot legally threaten a parent with a need to medicate a child. That is totally out of their realm of expertise as far as medication is concerned. And again, failing grades don't have to be present. IEPs don't expire if it has to be postponed. And I heard a terrible story regarding that too, where a school district was threatening parents that if they didn't meet on a certain day, the IEP would expire. And so they weren't there for the meeting, and the school ended up having the meeting without the parents. That's just not ever to happen. That is so untrue. And it was a manipulative thing to do to these people because they couldn't make the meeting, and they agreed that for the school to have the meeting without them because they couldn't be there because they were so afraid it was going to expire. Terrible. Can't expire. Parents must be invited to an IEP meeting, and they must be included. And again, I said there has to be certain people there: general ed, special ed, a case manager, and anyone else who provides services to the child. The district must follow the IEP within the state and transfers to another state. Again, the IEP follows until a new one is developed. So any kind of move within a state or into another state, you lose that support. And again, in certain areas, I mean, I think a lot of times I've read federal law trumps state law, but there are some state laws that differ. So if there's ever any question, you can certainly check your state requirements. You must, and I talked about this before, in the new IDEA of 2004, there has to be a specification of how and when reports on progress will be provided. You have to know that. And this is just really about the importance of peer-reviewed research and modifications or supports for school personnel. There's new language on needed accommodations on state and district testing. If there is a decision to use alternate testing, there needs to be an explanation as to why. Whoops. So this is our child with all of these questions. What am I good at? Who am I? What's my story? Who's going to help me? Who loves me? All of those things that have to happen so many times in our children's heads in the school, because so many times our kids, it's not a very friendly place. It's not a place where they feel success. So, and if only medications really were the cure, right? It's only a piece of the puzzle, and that's only if you personally decide it works. So another part of this webinar, I just want to touch on coaching and school support. Again, as I mentioned, coaching can't happen without good school support. Self-esteem, once there is school support, allows goal development, and that's very huge. Remediation allows goal achievement, and that I mean remediation in the areas of learning disabilities. Use of strategies allows goal achievement. Modifications and accommodations allow homework completion and goal achievement. Added knowledge and acceptance allows for effective self-advocacy, and healthy self-esteem becomes a circle of success. So these are just statements that, to me, reflect the importance of adequate school support in order to be successful. I mentioned earlier a little bit about transitional services. The child ages out of the IEP under the IDEA at graduation or at age 22, whatever comes first. Then, if your child's going to college, the 504 is what really is in place and allowing accommodations in college. Every college has a disability office, for those of you who haven't gotten there yet. It's important information to have. In the IDEA 2004 states that the first IEP after age 16, a quote, appropriate measurable post-secondary goals, age-appropriate transition assessments related to training, education, employment, and where appropriate independent living skills and the transition services needed to assist the child in reaching those goals. So, obviously, the IDEA is just addressing this child with a diagnosed disability that at some point by age 16, but it is actually in some states it starts a little bit before that, but at least by 16, there are some transitional goals in effect in fact, and so that there can be some movement toward those goals. And so that's really when, too, you can think about having your child be at an IEP meeting. Now, a little bit about behavior. Again, the school has a responsibility to provide FAPE, as we've talked about, and address that behavior. And any children who have combined type ADHD are going to sometimes have some behavioral issues. They can suspend a child for up to 10 days. There must be a manifestation meeting to determine if the behavior was part of the disability. They can't impose long-term suspension or expel if the behavior is a manifestation of the disability or if it's school failure to implement a behavior plan. So this is where the red flags start. If there is no behavior plan, then there must be one developed. In this case, if there's something like drugs, weapons, some kind of weapon of any kind, a child can be placed in an alternative setting for up to 45 days, but FATE must still be provided. So there's a lot of behavioral issues that, certainly we're going to hope that, generally our kids aren't going to some alternative setting. But what I'm saying is that behavior can be a huge issue based on a lot of the like behaviors that we talked about earlier in the beginning of the webinar, and must be addressed. They apply to those who are not officially diagnosed, and that is crucial. The law applies if a parent previously expressed concern about a disability, asked for an evaluation, or another teacher expressed concern. So you see how the law is somewhat protecting the family and the child if there's some behavioral issue, because this came up, which again is why it's important to keep all documents, document everything and keep everything. And then if there is a suspension, there can be an expedited evaluation if it was originally there was a no. There can be. Behavior plans can be very complicated and should not be, or they're not going to be successful. 1 to 2 goals, positive goals. A child has to have input into those incentives for that to be successful. There should be some built-in success and communication and reinforcement from home. Whoops. So I think just wanted to make sure I guess I didn't get it missed. So the most important thing here, I think, is when they have adequate school support, there is an improvement in the parent-child relationship. There is an improvement in self-esteem and understanding themselves, and and the ability to establish goals and to be successful and to understand themselves better. Very important. So we are at the end of the webinar, and I wanted to see if anybody had any questions that they wanted to ask. Feel free. You can write them in the question box. Does anyone have any questions? So a question is, Can I tell you where the IDEA says that there's no longer a necessity for a deficit formula? No, I can't offhand, but I could certainly, if you want to reach out to me, I will find those exact words and send them to you in the IDEA. But it is it has documented that in many. I need to find the exact number of that ruling, and I can send that to you. That's not a problem at all. Offhand, I don't have it right now, but I can certainly do that. If you want to send me an email, which is on the PDF, you can write me an email and I'll respond back to you. So the point of that is that, I think that, maybe at some point it was thought that, and I think for good reason, that not necessarily are you going to have that deficit in a child with a disability who is struggling. So the many of these impairments of ADHD are impairments that are seen but maybe aren't tested out, and it's just you're unable to see that. But I'll be happy to do that. I should have written that down so that you could have seen that, because it's very important. Anybody else have any questions? The person who asked me about the formula, is that something that your school has said to you? Just out of curiosity? I'm not sure if any of you, what your age of your kids are. So, here's another one. Can the district make me sign a mediation agreement that I am not happy with? No, the district can't make you sign anything that you're not happy with, and I would never sign anything that I wasn't happy with. So I'm assuming that you went to mediation and they want to move on with some kind of agreement that you're not happy with. No, because I guess they want to make sure you're not going to due process, I guess. No, I would definitely not. I would put in writing what your disagreement is in that mediation agreement. That's what I would do. Oh, I see. I didn't see that before, Barb. Your district uses 25% number for a deficit. Yeah, I've heard that in a couple of districts, and they're adamant about these percentages. Yeah, I will definitely you definitely reach out to me so I can write down the exact number in the IDEA that specifies this law that I'm talking about, because they can't use that deficit. All they can do is, what you're supposed to do is just prove that the impairments of ADHD and or the scores on the evaluations are adversely affecting educational access. Now, that's what the law says. If your child is limited with accessing education, then that's something to look at as far as support. And the formula is not part of that at all. Yeah, Marcia. You can call a meeting every other week if you wanted to. You can always call for an IEP meeting anytime. And sometimes I've seen where parents don't understand that, because certainly that's not going to really be something you're encouraged to do. But I really think, especially because kids change so much and the requirements change so much. I mean, I personally, with my son, I don't think there was a year that I only had one meeting, and not at all. And generally, I was the one that called meetings, and they have to have that meeting. Now, sometimes you can be on the phone with a case manager, and maybe you've had some issues with um, a modification, or something's not working correctly. You want to tweak it, or you want to add something. Sometimes they will agree to not have a meeting and add that to the IEP, and that's fine, as long as it's something that it's not a big deal that you feel you need the group there to discuss. That makes parents' lives easier and their life easier. So you can avoid the meeting sometimes, as long as it's being added, and then of course you're sent the new draft of that IEP. The goal is evaluated based on structured interview. Um, no, not necessarily. I guess are you talking about the SMART goals in the IEP? Um, those are evaluated quarterly based on whatever measurement that the school has said they're going to use to determine that. Whether it be a functional goal like organization, a goal that has to do with maybe handing homework in, something like that, versus a remediation goal that could have something to do with a learning disability. And you want to increase, maybe fluency is a big term used. Fluency that, this child can read X number of words a minute, and you want to get that fluency to another level. And so what kind of testing, what kind of evaluation do they use quarterly to determine whether that goal is reached or not? If I didn't understand the question, ask me again, because that's what I'm getting. My son's cyber school, I believe, did not comply with laws regarding IEPs. I argued for 2 years, but they would not budge. They finally forced him out for not keeping up. I don't know where to go from here. Do you have any suggestions? Oh, brother. Um, hmm. I guess I would have to know. I'm not sure. Some of these schools, online schools, I guess that's what you mean. It's an online school. They may not have to comply, because the public schools have to comply, have to offer those kinds of supports, because they're receiving federal funds, where private schools don't necessarily have to. And I would think cyber schools don't have to either. So I wonder, I guess the question would be what the argument was for 2 years, what was going on with him, and why they wouldn't budge, why they weren't helping him, if they felt they didn't have to help him. Um, it may not have been the right environment for your son. It may be that they didn't They didn't have the kind of support that he needed, and they didn't legally have to. So I guess my question to you would be, would you consider him, I don't know how old he is, but would you consider him to go back to a public school setting and have him, I mean, I don't know anything about whether or not he was evaluated, but if he was, if it was longer than 3 years ago, then he needs a reeval anyway. Maybe he needs to be reevaluated and looked at as far as what kind of supports does he really have. If he wasn't keeping up, that could be for so many reasons, processing issues, organizational issues. I don't know. Maybe you do have an evaluation and you do know, but the question that they were not budging, they felt that they could legally do that to you is concerning. And it sounds like it was a good place for him not to be. But I do understand many times people who go to an online school setting are the people that had a lot of problems in public school and went to that as an alternative. And maybe that's where you are right now. And I don't know how long he was in public school and how many problems there were, but um, maybe that's something you should consider to try to go back and make sure all the ducks are in order. Can a district refuse to test for social emotional issues? I don't think so, because those issues impact educational access. And a child with those kinds of issues, like maybe, do you mean anxiety, are impacting education? So no, they can't refuse. If that's an issue that's affecting that child, um, it needs to be addressed. Yeah, definitely. I don't know why they would refuse to. Oh, this is about the okay, for the cyber school. His scores were in the 99 percentile, but his working memory was in the 13th percentile and his processing speed was 5%. They said he was handicapped and no longer qualified for an IEP because he didn't need special education. Oh, wow. That's like unbelievable. Well, again, those two areas, working memory and processing speed, certainly connect with ADHD so much. And that is limiting to his educational access for sure. So they say he's handicapped, but he doesn't need special education. Wow, they're totally wrong. Um, so apparently they do deal with IEPs. So if they do, I mean, I don't know. Well, I guess you said that he's no longer in that program. Um, if they're bound to follow a child with an IEP, I don't know how they don't support his needs and say that he can't do it and kick him out. I don't know how they get away with that. That does not sound legal to me. I'm just not sure that how bound they are because they're a cyber school. I've never really looked into that. Those online schools, I'm not sure. They're certainly, I mean, I wouldn't think they're receiving any federal funds. So I'm not sure they're bound to follow an IEP and they can get away with this kind of stuff. But I do know that if you were in a public school setting and you had those kinds of percentiles, they could not say that. He would definitely have an IEP, and the goals would be around those kind of processing speeds and working memory, because those issues impact so much in the classroom as far as accessing education. That is special ed services. They're totally wrong about that. So I would ask them, what is your definition of special education that he doesn't need? Because he does need it. He does need some modifications along the lines for him to better be able to process information and remember, and move like short-term memory into long-term memory, those kinds of things. And those are all related to ADHD, I'm sure. That's awful. But again, I would be questioning the kind of school this really is, and I don't know whether it would be worth arguing with that or putting him into a public school and making sure he gets services. Um, the goal is evaluated based. Oh, wait a minute now. Sonia, let me get back to what you said. Oh, the IEP says that's how it will be evaluated? Whoa. Well, structured interview? What goal are they evaluating by a structured interview? That doesn't make sense to me. That's very vague. I would not let them get away with that. I guess my question to you would be, what kind of goals does he have that they say can be evaluated by a structured interview? I've never heard of that. He's 11 years old. The school's attorney told me I must sign an agreement by 5 p.m. on the date they requested. Okay. Well, what happens if you don't? You don't agree? Uh, I think that schools' attorneys, because I've dealt with them, can be very threatening, and they're just trying to scare you. I've actually never heard of that, where a school was threatening a person to sign a mediation agreement. Usually what happens is, if the agreement is, if the mediation occurs, the person comes down from, well, in our case, New Jersey, they come from Trenton, but wherever, and it's the mediator and the school attorney, case manager maybe, and then on your end, you don't have to have an attorney for mediation, but either that or an advocate. I don't know if you had an advocate with you. You don't have to have that either, but whatever. And the mediator goes between, I'm just saying this for the rest of everyone to know what she's talking about. The mediator goes between the school attorney and you guys and tries to hammer out something that can be agreed upon by both parties. And if it's not agreed upon, then the next course of action is due process. And due process is, standing before a hearing officer or a judge. And it's not something that schools or parents want to go through. It's a last-ditch effort. And I'm sure the schools don't want to go through it either. That's why they're trying to get you to sign this agreement, because it costs a lot of money to go to court. And many times parents are hurt by it. Many times the court system favors the schools. That can happen. But what I've also heard, and I've never personally gone to due process, although I did almost go, And so I had talked to an attorney about that, and what I was told was they certainly don't want to go to due process any more than you do, but if you start the process, they'll probably make a deal with you to avoid it. If you have your ducks in order, if what you're asking is something that's realistic and they know that, and they know they're going to lose. So I don't really know the whole story regarding this whole thing. So it kind of depends on, I'm assuming that you initiated the mediation and I don't know why. Um, but the fact that they're making a big issue about you signing it sounds to me like they don't want to go to due process. So, I mean, I would put in writing instead of, you don't want to look like you're ignoring anything. I would put in writing or well, you can't ask a school attorney because the school attorney is not on your side. But I would put in writing what you don't agree with in the mediation. And I don't know that you want to go to a due process because it's expensive. And I don't know whether it's worth it depending on what you're asking for. So there's a lot of questions that I have right now, but yeah, I've never heard of that. But again, I think it's because the school is afraid you're going to go to due process and they don't want to do that. I mean, you could write that you don't agree with mediation or you don't agree with X and Y of whatever was written in the mediation agreement, and that you were considered moving to due process because of the lack of resolution. Child recently evaluated, not evaluated in all areas of disability. School offered a 504 plan acknowledging the disability, but does not impact learning. Now paperwork, new 504s acknowledging she has issues with reading, writing, and math that significantly impacts her learning. Doesn't this now qualify for an IEP? Yes. I was just going to say that. Yeah, absolutely. So your child was evaluated, but not in all areas of the disability? Huh. So they thought they could offer a 504? Now, why? So I don't really understand that. Then suddenly now they're offering a new 504 and they're acknowledging she has issues with reading, writing, and math. Well, yeah, that's an IEP. She needs some reading. It sounds like she needs remediation. I mean, I don't know what her evaluation looks like, but if she's got low scores, she needs an IEP, not a 504. Um, I'm always struggling to understand why schools sometimes push people away from 504, or I mean IEPs. They are receiving federal funds, but two things. It may be that the federal funds don't cover the cost of really running an IEP, and the services that need to be provided cost money as well. That's the only thing I make sense out of some of the things that I hear and see that don't make a bit of sense to me at all, but that are trying to push parents away from getting adequate support. And this is one of them. It would cost money to provide an IEP because of, obviously, it sounds like she could need some remediation in those areas. And they know that. And if you have in writing that they're acknowledging that there's issues, I find that interesting because they're acknowledging it. So I would think that you might want to, um, if they're not willing to consider IEP eligibility, then I would ask for an independent education eval, which you can do when the school's evaluation is not complete in your world. You don't think it's complete enough, or that you both disagree. You want an independent evaluation, and the school must pay for it. That might be the next thing you do, and get another evaluation privately. I just have to remember who this was. Marcia. Your school told you no to an IEP meeting? Am I getting that right? They can't tell you no. They have to have a meeting if you want it. If you have issues, you have to have it. No, you can't let them do that to you. Am I getting that right? The school told you no to an IEP meeting? Yeah, I guess that's what you're saying. Wow, that's ridiculous. Tries to discourage it. Well, yeah, they don't want to drag everybody into a meeting because it takes time and energy and everything else. But that's what happens when you don't have an IEP that's functioning correctly, or there needs to be some tweaking. You need to have a meeting. You can file a complaint against the school for not following the rules of IDEA. That's what I would look into, or at least say that you will file a complaint until the IEP meeting is scheduled. Nobody wants any of that nonsense to happen. As long as you let them know that you know what the law is, they will probably concede. The tester said his low scores were discounted because they were more than 2 standard deviations away from his others. They are the definition of a learning disability. Wow, yeah, I don't even that yeah, it doesn't matter, Valerie. I mean, they can talk about all the deviations they want. He's got low scores in those areas that impact his learning, and then if you can connect, you can prove that the struggles relate to those low scores that impact his educational access, then that's why he needs support and he needs an IEP. They're just telling you bad information. Yeah, I mean, that's very significant low scores, and he's even admitting that they're low, but yet at the same time not really addressing a learning disability. So I guess I'm confused why they're saying that. So I think what I would do is just, again, I would place objective data with that relate to the scores in those areas and how it impacts his education. So Josie said, I signed it, but wanted to cancel it before the 2 days, and their attorney told me that I can no longer cancel it, and this is because they did not want to do a psychological evaluation, and I knew I had a good case. But their attorney stated by email I had to go in to sign by 5. Does this make this agreement void? I don't know. So you were told that there were 2 days in which you could cancel, and the attorney told you no? Yeah, I would, this whole thing doesn't make sense to me. I guess what I would do is, they're just trying to, again, keep you under their thumb and just have you agree to a mediation. If there was a period of time that you had the right to cancel and he told you no, I would make sure that, I hope that was all in writing on his end, and I would reach out to the state educational department and find out how you can file a complaint against them. Just make sure you get your facts in order for that state, because I don't know what it is. I think you're the one who's in California. I would not let them get away with that. If there, and usually there is, first of all, you were coerced into signing, and then you had a time frame where you could back out of it, and you were told you couldn't, is what you're telling me. So I would like really have to verify that with the State Department and see the education department in your state. Find out whether or not you have some grounds here. Yeah, Sonia, I've never heard of that. Evaluating a goal by structured interview? That makes absolutely no sense to me at all. If I were you, I would call an IEP meeting to talk about that and to revise how you are going to evaluate goals, because that makes no sense whatsoever. How in the world do you evaluate a goal by a structured interview? What goal is it that we're evaluating that would be you could evaluate by an interview? It doesn't make any sense to me. I would change the IEP so it's in language that we all understand. Yeah, very weird. No additional testing done between draft 504 and finalized 504. Hmm. So they changed the 504 with no reason? Or they're now acknowledging that the previous testing shows that he has a learning disability? Yeah, I would, if you think he needs an IEP, which to me, everything you said points to that, and they're denying that, I would ask for in writing an independent educational evaluation. So it's a private outside the school where they pay for it. They The first year's teachers made accommodations and gave supports. It was wonderful. The next year they said it was high school and he should be independent. They ignored his 504. Yeah, they can't do that. The teachers cannot make those kinds of decisions about whether or not a child needs a 504 if they have one. They have one, it's a legal document, and they have to follow it. And I love how I've heard that so many times before, where um, this happens a lot to our kids in high school, where the teachers believe that, again, in a different kind of a way, this is a behavioral thing, right? He should be independent. He should be able to ask for things he needs. He's just being lazy. He's not trying hard enough. All the time. Our poor kids in high school get told that all the time. And they don't understand that um, they want to succeed. It's not that they don't want to succeed, but they need some kind of scaffolding to allow for success. I mean, these kids with IEPs move on to college and they have 504s in place there. The disabilities office can't turn their back on them as long as they go into a college setting and the testing they've had is within a 3-year period. They meet with a disability office and they can list the accommodations that they believe they need for their own success and follow those. My son does that. Um, the important thing about an IEP is that while it's still valid in high school, if you have learning issues, then you want to do as much remediation as you can, and for areas that are not as remediated as you would like, to learn the strategies to be successful, because once again they leave high school, they don't have that IEP anymore. They only have accommodations, just like accommodations, meaning that they need to follow the curriculum, but the playing field will be leveled by those accommodations, like notes, recordings, testing in a quiet place, that kind of a thing. But it's nothing like an IEP. So if any child needs an IEP now, when they're in elementary, middle, and high school, they should have it, because now is the time to remediate the issues, because they won't have it when they graduate. They won't have it. So, to ignore any legal document of support is horrendous. And to take on the knowledge to think that you can say this child has ADHD, but he could do it if he wanted to. That is not what this diagnosis is all about. He would do it if he could, because he wouldn't want to listen to that kind of awful negative behavior thrown in his face. That is so not true. He needs strategies and scaffolding to learn how to become successful. And at some point, hopefully, he doesn't need it anymore. But that's what he needs. That's how he learns. That's part of the diagnosis. And they can't do that. They can't do that. So if any kid's 504 is being ignored, they need to, if you're dealing with a school and it's not working, again, you can go to the state and file a complaint for discrimination, because that's really what it is. The 504 is preventing discrimination because of a disability. That's exactly what it is. So if if you have a child who has some kind of a physical disability and he needs a ramp or whatever, that would never be taken away, right? But if you have a child with ADHD and you got teachers telling you that you can do it if you wanted to, and I'm not going to provide these accommodations, that's the same thing as taking the ramp away. The same exact thing. And you can't let them get away with that. It is a disability that requires that particular support or more. I don't know. At some point, maybe he needs an IEP. I don't know. But I'm just assuming if 504 is effective, if 504 is followed and is effective, that's great. You don't need to go to an IEP if you don't need it, right? But the problem is you don't know for sure if you need it, because you don't know whether the 504 is being followed. And in this case, if it's not being followed, then you don't really know what he needs, because you don't know whether anything is being followed consistently. That's not fair to him. So I would file a complaint if they don't follow it. Make it clear. Sometimes it's just important to let a school know that you know what the law is, you know what your child is due, and you expect it to happen, and they will make it happen generally. Who wants to go into a fight mode? Who wants to send out complaints and all that kind of stuff? Nobody wants to do that. Um, but maybe you document that possibility that you're going to follow through on something like that, and maybe things will change. Yeah, they're all coming separately from lots of people. So if I have to refresh my memory, I have to go back up and look and see what you guys wrote. Yeah. So Sonia, the goals are emotional goals and they are evaluated by structured interview with the psychologist. Is that an accurate way to judge the goal? I don't fully trust the psychologist. Is there a better way to judge the goal? Huh. Oh, that's what they mean. Okay. I don't know. If you don't trust the psychologist, then no. And I think that how I would expect it to be, I mean, you could, I mean, I guess if you could throw that in if you like the psychologist, but I think I would be more apt to judge uh, the achievement of a goal by how, um, the present levels of functional performance and all of those things that are written down about your child. How is that affecting success in the classroom? That's how I would think it would be important to get information from the teachers on a quarterly basis. And currently, how do those impairments affect her success currently? And what is the action plan to improve and achieve those goals? And quarterly, what are you seeing that's different from like last quarter in the classroom? I would rather do it that way. So it's like a more, you know what I mean? Like it's a more objective data situation. This is what happened. I mean, obviously, there's things that are not happening in the way that you want them to happen, or you wouldn't be having an IEP to begin with. So, whatever is happening in the classroom or affecting her grades or affecting her achievements, affecting her homework, anything like that, that's objective. Then you can look at that data and say, okay, so now quarterly, this quarter, this is what's happening, and compare it to other, teacher comments as well as yourself, because you're the one also living with her and knowing her achievement levels. But to only evaluate by structured interview, um, you're not in the environment where her emotional deficits or whatever is happening is affecting her. So I don't know that that's really a good way either. I think, again, I don't know if I'm making sense, but that's what I think. I think you should really, whenever you can, use objective data, not subjective data coming from a psychologist. Yeah, it's okay to throw that in, but what about the objective data? Why do we have an IEP with goals that are emotional to begin with? Because they're affecting her educational access. What is being affected and how is it being affected each quarter? Have things changed? What's the action plan? What can we change? What can we tweak? If that makes sense. If I get an advocate for my child, do I lose rights as a parent? No, not at all. Absolutely not. A parent and an advocate together, no, you're still the parent. You don't lose anything. Advocate is just a supportive person. Um, and I'm telling you, because I've gone into enough school meetings, sometimes just the mere presence of an advocate makes things a whole lot better. And in those cases, then you know that the school knows better, which is kind of sad. You were saying we could do amendments without calling a full meeting, so that may work. Yeah, as long as they agree to that. as long as all parties agree to it, you certainly can do that. Yes, absolutely. Who would I do the amendments with if we didn't have a meeting with the full team? Like if we needed to add something but don't need everyone there, would I bring it up with the special ed teacher? No, I would put it in writing to the case manager, because your child has a case manager. She's the one that needs to know that you want to make a change. This is what you're seeing. And if she believes there needs to be a discussion with all present, then she'll tell you that. It kind of really depends on the tweak that you're looking for. It may or may not work, but definitely put it in writing to the case manager. So Tony said, I have requested an IEE and was very specific why, and after 3 weeks they are further questioning me on the concussion. Doctor's request for a neuropsychological eval and wants my list of reasons why, even though I have told, wait, them I do not agree with their email as they have not evaluated in all areas. What is the timeline they either have or respond to my request to accept or deny an IEE? Yeah, I've never really seen a specific time request. Again, it's supposed to be reasonable, 7 to 10 days maybe. But they have to respond. They have to either agree or go to or file for due process to prove that what they did was enough. So, what did you say? 3 weeks? Yeah, it's way too long. Yeah, that's way too long. 3 weeks, and they're still questioning you. I mean, you don't have to list a bunch of reasons. You just don't agree with their evaluation. But they should have accepted or denied it by now. They're way beyond. 3 weeks is not reasonable. So you were told that you could cancel after 2 days, and he said no? Wow, that's a lot. So, everyone, this is still the same. Josie is the same person who's being forced to sign a mediation agreement. You were told that you had 2 days to cancel after signing the agreement, but their attorney said I could not do that. I requested for an independent eval, but they refused. and filed for mediation and due process. The reason they did this was because the person that did the first IEE was picked by the district, and I found out the psychologist had worked for the district in the past. So when I told them this, they refused to pay for another IEE because they know they are tweaking these psychological evals to better suit them. I had an IEE in speech and language, and the speech and language evaluator stated in writing that the lack of assistance from the school has made my son get behind, and she recommended explicit academics with Lindenbell mood, but they refused to do this. Wow. Your district is kind of tough. Oh my gosh, that's unbelievable. Yeah, you have a very serious issue. Hmm. Well, I think that we are now pretty late. And I'm going to kind of wrap this thing up. If any of you guys, since we've gone over half an hour, would like to further discuss any of your concerns or questions, I would be happy to do that. As I had said, I do offer free consults on the phone, and please reach out to me, and we can discuss more specifically your areas of concern, and I'd be happy to do that. Thank you so much for being here. I appreciate you attending my webinar. And again, anything I can do in the future, please reach out. Thank you so much.